Thank you very much, Madam Chair, and thank you very much to all of you for being here. And Ms. McTeer, to you and your committee, thank you for your work, and to Justice Martin, who I had the pleasure of being on the committee when she was appointed and asking her questions, former McGill grad, of course. I appreciate her service on the court. I just wanted to say how much I appreciate this process, and I appreciate as well the lack of politicization that goes into appointments in Canada. For example, in the United States, we all know that in both 2016 and in 2020, President Trump said he would only appoint justices from a list selected by the Federalist Society. I mean, that is true politicization of the court. Here we have an independent process where a selection committee appointed by various different distinguished bodies across the country is able to ascertain of anyone who wishes to apply whether or not they merit being submitted to the Minister of Justice and then to the Prime Minister on a short list. And I think that is an incredibly good process. Ms. McTeer, in terms of the process itself, in the past, if I remember correctly, there have been 3 or 4 candidates that have been submitted to the Minister of Justice by the committee. Is there any reason you can explain to us why it was 2 this time versus the normal 3 or 4?
Yes, I can. We had extensive discussions, and we decided that those 2 who we were going to present were so exceptional that that was the decision, our consensus, that we would only nominate 2. It wasn't a precedent. That was set the last time with when Mr. Justice McLaughlin made it clear, for the same reasons we had, that while the requirement was for 3, there were really 2 so exceptional that they were the ones that would be best presented to the Prime Minister. Now, the Prime Minister, of course, as Monsieur Fortin has mentioned, has the ultimate authority and could have returned to us and said, sorry, I want 3 to 5. And we would then have to give some thought, which would be very difficult for us, given we had already made our choice. But that didn't happen, as you know.
I understand. The only reason I raise this is, then the committee could one day say there's one candidate that is so distinguished and so much above everybody else that I am going to only propose one. That's why I kind of look at that, and I'm concerned, but I understand the point. Can I also ask, were you concerned about the fact that there were only 9 applications given in the past? There have been times that there have been significantly more applications?
It seemed low to me. Given the vastness of the region that we were choosing from. It was, I think, if you've looked at the questionnaire, you realize it would take time to put together such a questionnaire. So time, and we're not saying anything new, other groups have said it in the past, the more time you can provide for this process, the better it is, not just for our work, but for the applications. And that's why one of the things I hope we can do is continuously look to see who are the best and the brightest in Canada, who are people who would be qualified, because the application process allows anyone, given a narrow, but still anyone basically, if you've practiced law or even been a member of the bar for 10 years, you can apply to be a Justice of the Supreme Court of Canada. Maybe in terms of the application process, we need more time. We need perhaps more education across the bar. We keep more on the lookout, those kinds of things.
Can I ask one other question? I mean, I understand that you proactively interviewed the 4 final candidates in terms of in-person interview. You did enormous diligence based on their questionnaires. Did you also, I assume, do heightened levels of diligence with respect to things that they may not have disclosed in the questionnaire? I'm sure they were subject to credit and criminal checks and, and other similar types of publicly available open source information. But can you assure us that, whoever would be chosen, I'm not speaking of Justice Joyal in particular, that this is, that it has been screened as much as a green light committee would screen a candidate for any of our political parties?
Well, we do that element based on the applications and our reading and our question and answer session. The rest of it is done by the Mounties. It's done by the those who have authority to do that kind of check.
One final question, if I may, Madam Chair, very short. Mr. Minister, could you just assure the court that, you know, again, in the United States, there's often presidents who say we have to have an originalist, we have to, or a prime minister that might say we need somebody who embraces the living tree doctrine, or a strict constructionist. Can you assure us that you did not put any kind of litmus test on the philosophy of the judge that you would have recommended?
Yeah, look, I'll entirely will endorse that perspective. I've put no such pressure on anyone through the process. Just maybe a comment to complete the answer. Some of the most beautiful things about the country in which we live are invisible to those of us who call it home. But when you actually start talking to people from around the world and they look at the protections that we have in place for our democracy, for our courts, for the independence of the judiciary and the rule of law more broadly, they blush with envy. Try attracting investment to a country where the judges are in the government's back pocket. It's not going to happen. We are very, very lucky to call Canada home, sometimes in ways we don't appreciate day to day.
Thank you, Madam Chair.